Good morning and welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media for HAR, and there is a very important topic on every member's mind, and we know that. And so today we're here to discuss the NAR settlement and what it means for you. And with that, we've invited back to the program HAR's legal counsel, Grant Harpold. Welcome back to the program, Grant.
Good morning, Christina. Great to be here.
Absolutely. Thank you so much for taking the time to come on. We know you're very busy trying to help guide us and analyze everything. And with that, obviously, there's so many questions from members. I've compiled a list of some of the most common questions I've seen. And we're going to talk about all of that today. But of course, for those that are tuned in, if you have questions, please feel free to type those in the comments. We'll answer as many as we can today. But before we get into all of that, Grant, tell us a little bit about yourself. For any member who doesn't know who you are, tell us who you are and what you do.
Well, as you said, I'm legal counsel at HAR. I'm board certified in civil trial law. I've probably over the last 30 years dealt with more broker agent issues in real estate than probably most lawyers in Texas. So I have a vast experience of dealing with these issues that come up with brokers and with change and everything else that's going on in the industry. So I'm part of the team and ready to go.
Absolutely. And you were such a big part of HAR, and many people might not know that. You sit in on board meetings, you sit on different advisory group meetings, you hear from our members and talk to our members and are able to guide us with that knowledge base. And we really, truly appreciate that.
Well, it's an honor to do it. I really enjoy doing it, and I love representing realtors because they're great people.
Thank you for that. So we've got some good mornings coming in for you this morning, and again, we have a lot to get into, so we're going to dive right in. I have some questions for you today that come directly from our members. That some common things I've seen on social media, but before we get into everything, I would really appreciate if you could just start the show by telling us in your words a brief overview of the terms of the settlement.
So I think it's just to start off. I think it's a good settlement in the sense of it takes care of a lot of issues. It creates some new issues, but overall, if it gets approved, and I say if because ultimately the court will have to approve the settlement, and there's going to be opposition to this settlement from some areas of the market or some people yet to be seen. But it probably take to the end of the year to get it approved by the court. But I think when you look at the settlement, it's doing away with the litigation that involves associations, brokers, NAR, and so MLSs owned by associations. So it's a big, broad sweep of peace and settlement for major players in the industry, from the association, from NAR, from actual members. The only ones that probably aren't benefiting yet from the settlement are home services affiliated companies because they're still fighting the litigation. But everybody else, whether you are named as a defendant or not, and I'm talking about brokers, get the benefit of this settlement. And so that's a good thing. And so overall, as far as the practical side, there are going to be some practical changes that the members will have to get used to. But here's the bottom line: is that the offer of compensation, meaning the ability of a listing broker or a seller to offer compensation to a buyer agent, still exists. That ability to do that still exists. The exception to that is that you cannot put the offer of compensation in MLS.
Okay.
But anything other than the MLS offer of compensation is alive. How well it is, we'll wait and see how well and kicking it gets, but it's out there, it's available, it will continue to be available. It just won't be available. That information about broker compensation cannot be put in the MLS, but it can be put anywhere else, and so that's a good thing.
So, Grant,
And
I know you're going to go over more terms of the settlement, but we've seen people already suggesting different workarounds, one of which just came through from Mitch Rainey. He asked, could the offer for buyer's compensation be added to the showing instructions on Showing Smart? So if it can't be in the MLS, can it be in a program like Showing Smart?
no, because Showing Smart is a part of HRIS and akin to our MLS, and so it can't be operated through something like that. Cannot be done through Showing Time since it's affiliated with HRIS, who operates our MLS. So that would be that wraparound, if you will, would not be available for for HRIS as an entity, or Showing Smart, which is a part of HRIS. So the answer would be no.
Okay, thank you for that.
And let me add this, Christina. Buyer's rep agreement have always been we've been talking about buyer's rep agreements for years and a lot lately. That's going to be an MLS rule as part of the settlement, that everybody will have to have a buyer's rep agreement if you're representing a buyer, and the agreement would have to be in place before the first tour of the home or the property. And when I say tour, I mean physical tour. It doesn't apply necessarily to a virtual tour, but the buyer's rep agreement it will be an important document, because now that will contain or have written language that will address how you as the buyer's broker slash agent will be compensated. And so that will be the main purpose, or one of the main purposes of the buyer's rep agreement, is to establish how compensation will occur. And why is that important? Well, the MLS is no longer having that information. So as we sit here today, we all know that if you bring a buyer to the transaction who ultimately closes and purchases a property, you know that through the MLS, you, the buyer's agent, is going to be compensated to some degree, some amount, and that will be at the closing. Now that's going away. That structure, if you will, for the compensation to the buyer's agent within the MLS is going away, but that structure can still be established through the buyer's rep agreement, giving you the authority to do it, and then also in negotiation with the seller or the listing broker as to what, if any, compensation will be available for the buyer's broker. So that opportunity still exists. It just exists outside the MLS.
Okay. Very good. We have some questions coming in, Grant, and I did share a slide on the screen, and we can share that in the comments as well. These are our Grants here, just kind of some of the top 10 points that he pulled from the settlement that we think our members should take a look at, and we're going to discuss a lot more of this today. Just want to tackle a few questions that have already come in. As we, I think the biggest thing that our members are finding is that offer of compensation won't be in the MLS. So they're looking for different ways, trying to get more clarity. Nasim asked here, so we can put an offer of compensation on social media, but not on the MLS. Is that
correct?
Accurate?
That's an accurate statement. You can put it on a billboard, you can put it in a newspaper, you can keep it to yourself, you can put it on a napkin at lunch, anywhere but the MLS. And so that part of the business is not going away. In fact, I still believe, based on my years of experience, that offering some sort of compensation to the buyer's agent is important, because it helps facilitate the transaction. It helps move the transaction along, and it helps bring a close and a closing to the purchase process by having that compensation available for the buyer's agent. I think that's good for everybody involved in the transaction.
Yeah, absolutely. So a few other things that I wanted to mention just briefly. The seller contribution. So that's another way that we're seeing people offering as a suggestion. What are your thoughts there? Can that still be offered through the MLS?
Yeah, seller concessions, buyer concessions, however you want to describe it, can still be part of the MLS. They can't be described or marketed or used as a compensation for a broker or their commission, but certainly the concessions that a seller is willing to offer to a buyer, some sort of closing cost adjustment or whatever it might be, are still available and can be posted and be a part of the MLS.
Okay, very good. A couple more questions that I want to talk about, and this is one that I've seen float around social media quite a bit too. Dimitri is saying, what recourse do brokers have in the event of non-payment? Who would they contact, and what documentation is needed as evidence?
So that's multiple issues there. If you have a buyer's rep agreement, presumably, and this is why it's important to have that language in there as to how you will be compensated, you want language in your buyer's rep agreement that's enforceable against your client if you have to go that route, which is the route of last resort. But the ability to get paid, if that's what you and your client agree to. Maybe the clause says you don't get paid if certain things don't happen. So one, it depends on what the buyer's rep agreement says as far as between you and your client. But as far as on the other side of the transaction, you'll have to just have an agreement. It can be part of
Mm-hmm.
the transaction, the purchase agreement for the property. It can be a side agreement. It can be an addendum to the contract. You just need language that A and B are agreeing to be paid this amount, that A and B agree to pay this amount to B for compensation involved in the purchase of this property. I mean, it's pretty basic contract. Yes, the
Mm-hmm.
MLS structure was there before that allowed that to occur, but the MLS structure was still based on an agreement or an understanding that the commission would be paid. And if that didn't occur, you still went to arbitration or some sort of mechanism to get it enforced. Same thing here. It's just not going to be in the MLS. It's going to be in your purchase agreement. It's going to be in an addendum. It's going to be a side agreement. However, it's documented.
Mm-hmm.
It just needs to be documented showing who owes what and what amount and when.
Okay, very good. And that, I think, answers quite a few people's questions. We had one from Erica saying, how will listing agents track this? Just ask the agent to email us beforehand.
Sure. I mean, it's like I said, offer of compensation is alive,
Mm-hmm.
and it should be well. It's just a matter of how well we make it, or how well you make it in your particular brokerage company or in the industry at large. It's from a legal standpoint, it's not a hard concept to put to rest as far as getting an agreement that says you pay this or you would be paid this in accordance with the terms of the contract. I mean, so
Mm-hmm.
it's and the terms of the payment for the commission should not be very lengthy or challenging. I mean, it should be pretty basic information that legal counsel for a broker or anybody else can come up with to help this process along.
Okay, very good. Thank you, Grant. I want to get back to some of the questions I have for you as well, but I do want to mention because I see people asking about leases. We're going to talk about leases. We're going to talk about commercial. We have all of that planned to discuss today, but because this wasn't a question I had planned for you, but a very important topic. Several are asking about VA, and I just wanted to address this. So, according to NAR, the VA has not been addressed whether it will change its requirement prohibiting VA buyers from paying commission. NAR is engaged with the VA on this issue, and NAR remains committed to working with the VA so that veterans are not left out of the market or forced to consider alternative loan products. So, I just wanted to share that because I've seen several people asking about VA. So thank you for those questions. And I see we have a few staff that are answering and helping out with the questions today. Again, we'll answer as many as we can. We tried to pick some of the most common questions and maybe some of the most difficult questions to ask Grant this morning. So that's what we're going to be discussing. So a question that I've seen from several of our members, again, we see a lot of things that float around social media, but one is, why do we have to abide by the NAR rules, and can we just ignore the rules?
Well, yes, you can ignore the rules, but that would not be what I would suggest. And why do we have to abide by the rules? Well, every organization has rules, whether it be legal organizations, real estate organizations, baseball organizations, they come
Mm-hmm.
with rules. And as far as being a member of NAR, there are certain rules that need to be followed, and specifically MLS rules. And so that's not a bad thing. That's a
Mm-hmm.
good thing. If the rule is a bad rule or needs adjustment, then work within the process to change that rule if possible. But that's just part of being a part of an organization, that certain rules need to exist in order for the organization as a whole. The rule is not for specific things; it's as a whole to make the organization work efficiently.
Mm-hmm. Very good. And to reiterate, you've mentioned it several times, but again, a common question that we've seen across social media is the offer of compensation going away?
No, it's like I said, it's alive. How well it is will depend on you as realtors to deal with it, and I think it's an issue you can deal with quite handily. You've shown historically you've been able to adjust to change. This is another change, and you'll do just fine. Offer compensation is alive, just not in the MLS. So go find another way to communicate, which is a big word going forward. Communicate,
Mm-hmm.
figure out a better way to communicate this information.
Okay, very good. So again, several people are asking this question, and it's a common one that I've seen as well. How will leases be handled?
Well, I think because the settlement talks about offer compensation in the MLS cannot be there, I think that applies to rentals. They haven't said that specifically,
Hmm.
okay? But I mean, just reading the language of the settlement is pretty clear that any sort of compensation to the broker, any sort of offer of compensation, any sort of mention of compensation to the broker within the MLS is forbidden
Hmm.
or will be forbidden. It's no longer allowed. And so that would apply to rentals too, because it has something to do as far as if the language in the MLS is related to compensation for brokers, it cannot be there. It has to be taken out, and there would be another way to communicate that information directly with the landlord or whoever.
Okay, thank you. How will this affect our commercial members?
I see no language in the settlement that suggests it has any effect on commercial. This is the whole lawsuit had its genesis in the MLS and in regards to residential properties. The commercial gateway is not an MLS. The property data bank is not an MLS. And so, unless they come out with a new pronouncement, I don't see any effect on commercial gateway or the commercial side of businesses.
Okay, very good. Um, just a comment here, and I have seen this comment quite a bit. Just wondering if you have thoughts on this grant. Nicole's saying it feels like not allowing the offer of compensation in the MLS, no matter what the amount is, creates less transparency within the industry. What are your thoughts there, Grant?
Well, that's a good argument, and that's the argument that NAR kept making that this is good for the consumer. It's the information's available. It's there. It's in place. It's all good, and so there's arguments on both sides of that. Apparently, that argument is going by the wayside as far as part of this settlement because that offer of compensation will not be in MLS, but the transparency of it and the knowledge of it still should be available to everyone involved in the transaction. There's no reason why the offer of compensation still won't be transparent in some manner because it's going to have to be discussed with you and your client between the buyer and the buyer's agent. And certainly on the listing side, it's going to have to be discussed as far as your discussion with the seller as to what, if anything, the seller was offering or authorizing you to offer on a listing to the
Mm-hmm.
buyer's agent.
Okay, very good. Thank you, Grant. I've seen this question coming up quite a bit in the comments, so I want to address it now, and that is, and this person said, Trek is Trek or TR or anyone providing a revised buyer's rep agreement.
Good question. And the answer is yes. I've checked with TR. Trek does not have a buyer's rep agreement to begin with. Trek does not have that form. So to
Mm-hmm.
the extent they develop that form, I'm not waiting on that, and nor should anyone. But TR, of course, has the form. TR is going to update the form between now and when these rules go into effect, or when this new policy goes into effect, which they should go into effect in August of this year. So not too far away that this change is coming. Roughly sometime in August of this year, these changes should be made. And I think TR will have changes to their buyer's rep agreement and to the listing agreement to comply with the policy changes that are brought about by this settlement.
Mm-hmm.
When those forms will be updated and changed specifically, I'm not sure, but will it be in time? Yes, it's my understanding they will be in time. I think the challenge, some of you may be thinking, well, what about my current listing or my current buyer's rep
Right.
agreement? Do I need to change that, or am I grandfathered in, or can I keep using what I'm using? I think in the past on things like this, when we've had changes at the state level through TREC or through the legislature, we've always taken the position that once the change is there and available, then go ahead and adopt the new form, get the new form in place for your clients because that's what the new law is or the new rules are. And so it's better to go ahead and operate under the new process or the new policy versus using a form that is now outdated.
Mm-hmm.
So what I'm saying is, once the new forms come out for a buyer's rep agreement or listing agreement, I think from my perspective, it's probably best to go ahead and get your clients to sign up on the new form.
Okay, very good. Kind of similar to that, discussing the new forms. Um, Jai asked, since this is not yet approved by the courts, are we still allowed to list the compensation in the MLS until that time? what is the time frame for the courts to make a final ruling?
So we have until August to make these changes. So these changes by use of the form, by the MLS rules, the, let's just call them policy changes
Mm-hmm.
that are brought about by the settlement that you posted earlier, have to be in place by sometime in August of this
Okay.
year. And so it's basically 150 days, not to get too legalese on this, but 150 days from when the motion to approve the settlement is filed. The motion to approve the settlement has not been filed yet, but is expected to be filed this week. And so once it gets filed, the policy changes need to be made within 150 days of that filing. The ultimate approval of the motion by the court probably will take until the end of the year, is what the lawyers are saying. That's because there has to be not evidence, but hearings and people voicing their opinion, filing motions, filing responses, filing whatever, to either say, yeah, we agree with this settlement, or no, we don't agree with the settlement. So there
Mm-hmm.
may be industry players, there may be consumer groups, there may be other lawyers. It's alphabet soup on who may show up and oppose this settlement. The NAR lawyers said it's probably going to be a 50-50 battle, meaning 50% in favor, 50% opposed, but ultimately they expect it to be approved by the court because the plaintiffs' lawyers and the defendants, specifically NAR, is in favor of it.
Mm-hmm. Okay, thank you for that, Grant. A few other questions that I wanted to address, and this is one that I've also seen. Jenny was asking, and I actually have an answer for this for you, Grant. Jenny was saying, my question is, are our NAR dues going to be increased? How are they going to pay this amount over the 4 years? And they've actually already stated their plan for this, Jenny, and for anyone else who's wondering. So HAR dues will remain unchanged as they have for the last 20 years. When it comes to the NAR dues, they have already announced that their dues will not go up in 2024 or 2025 because they've already made their payment arrangements and have mapped that out. So at least through 2025, NAR has said that they will not be increasing their dues. So a little more insight into the VA topic that we were discussing. Carlene Johnson, who is a part of a VA rep here locally in Houston, she says that it's my understanding that VA is waiting for the formal official statement before implementing any changes, and if they are internally exploring potential remedies that will benefit veterans and their homeownership goals. So thank you for that insight, CJ.
Yeah, the NAR settlement is 418 million
Mm-hmm.
paid out over time. I think it's 3 years it's paid out over. And you're right. NAR said the other day, no dues changes now or in 2025. I didn't hear any representation beyond 2025. I mean, just to be transparent.
Right.
And that, I think like I said, the payout is over time, but it's 418 million. And
Okay.
so I'll leave it with that.
So something else that and even in Bob's newsletter this past week, he said if you're looking at news sources, try to look at some of the industry news sources, maybe not the national news sources. Gwen just said here, will anyone make this correct information to the public? People are thinking they no longer have to pay. I know that here locally in Houston, we've been working with local news sources to make sure that this information gets out there and trying to set the record straight a little bit. Do you know of anything on the national level that's being done as far as media is concerned or communications?
No, I'm sure NAR is cooking up something
Mm-hmm.
publicly to deal with it, and it remains to be seen how well their public information office handles that. From my perspective, I think it's all local. I mean, you being the member, you being the realtor, you need to communicate this story. You
Mm-hmm.
need to explain it to your friends, to your clients, to your prospective clients. You need to sell yourself and the value of your services, and that's always been true, and it's
Mm-hmm.
true again. It's a reaffirmation of another truth that most of you should live by, is that I need to communicate the value I bring in the transaction, whether it's on the listing side or the buying side. And there's a lot of things that the buyer side agent does that the listing side or the seller or the public or the national media or whoever doesn't seem to realize. And so
Hmm.
that story needs to be told well, that what the buyer's agent brings to the transaction, not only on behalf of its client, but frankly on behalf of the seller, who ultimately gets the fruit of the purchase money from the buyer. And so it's communication, and
Hmm.
and everybody needs to be good at that, and actually even up their game on the communication of the value of your services and why you should be compensated, or why the buyer's agent should be compensated, or why this transaction is being structured this way, or why
Hmm.
we're putting this in the buyer's rep agreement. That needs to be explained and communicated, and I think you'll be fine.
Okay, very good. Thank you for that, Grant. So, one thing that I wanted to address with you, because again, these are proposed changes, they need to be approved. Any rules that might change, that's all kind of up in the air still right now on some of this. So, what are some things that our members can be doing right now to prepare for the upcoming changes?
I think stay informed of what's going on. Read everything that's out there, and like I said, I think you need to kind of look at your communication subjects, or how you're explaining the process, and tweak what's going on. Don't be embarrassed or apologetic. There's nothing to apologize here for. There's nothing to be embarrassed about it. Where there's some tweaking going on in the industry.
Hmm.
In theory, people think it's better for the consumer. There's a debate on that. You can have that discussion too, but I mean, all of it is in an effort to bring an efficient product to you in the purchase of the house or in the sale of a house. And so
Hmm.
that's what we're all working towards. And so that's what we need to be looking at, is to define our role, make sure the client understands our role, and make sure the client understands how the transaction works, and why this price is selling the property is not so much determined on commissions, it's determined on market value, and just sort of a re-education, not just for yourself, but for the client that you're dealing
Hmm.
with.
Absolutely. So, how else and I have more questions for you, more from the audience, but I think this is a good point for us to just mention how can members stay informed about the upcoming changes as things are rolled out?
How can what?
How can our members stay informed about any
Oh, I'm
changes?
sorry.
Yes.
Well, we'll be on the lookout for things that we send out, we being HAR.
Hmm.
Watch what NAR sends out, what TR sends out. So there's three. You're getting, this is a bonus. It's like a triple bonus. You have three sources of information that either will be sent to you directly by email because of your membership, or you can go to their website, HAR website, TR website, NAR, and find all sorts of information that can be helpful. So there's direct websites that we know contain information that can be helpful. Then there's just information in general on the web that can help you find it or guide you in this regard. So
Hmm.
I think I think you'll be fine. Look, I mean, I was around when seller disclosure notice came in back in 1995, and it was like wow, it was like earth changing. And of course, we look back now and think, how did we ever not have seller disclosure notice? So changes can be difficult, but I
Hmm.
think this change is transitionable into a process that will work for everybody. It's just diving into it, and going ahead and taking on the task and getting it done. And I think everything will work out just fine, because like I said, offer of compensation still exists. It's just not going to be in the MLS.
Thank
Buyer's
you.
rep agreement has always been around. It's just going to be more prevalent, presumably, and that's not a bad thing. There's always a listing agreement with the listing agent. Why not have one with the buyer's side, if you will?
That makes sense. And if I may, a few more things here locally that you can do, and I know we've put a few things in the comments for you. Make sure you're receiving emails from communications@har.com. This is how we, one of the main ways that we try to communicate with all of our members when there are major updates. And we did post, if you realize maybe you haven't been getting our emails, maybe you opted out by accident, we did post a link to where you can opt back in to those emails. Something else you can do, I know we have Bob Hale watching live with us this morning. Bob puts out his newsletter every Friday. That is something that you should be reading. If you prefer an audio version of it, you can also subscribe to the HAR On the Move podcast. We produce an audio version that's also released on Friday mornings. You can also visit har.com/lawsuits. That's being updated pretty much daily as new information comes out. So make sure you are taking advantage of those local and national resources from NAR as well. Grant, I have a few more questions from the members, and I do encourage, if you are somebody who's watching the live version of this and you missed parts of it, I encourage you to go back and watch it from the beginning, because I'm seeing some repetitive questions here, but they're so common. I do want to just quickly have you address these one more time. In regard to the offer of compensation, can it go on a rider? Can it go on social media? Can it go on a billboard, as you mentioned earlier? Where can that be displayed?
Two things. One, let me just compliment you, HAR, on the information that it provides to its members. I'm a member of the state bar. We don't have near the resources that y'all have, because you have HAR, you have TR, you have NAR to gather information. We don't, and so it's so feel good. So I can tell you, you're getting a lot of information, and you will get a lot of information, and you're in a good position on that. Yes, I'm going to say it again. Offer of compensation is alive and well. It's just a matter of how well you make it. You cannot do it in the MLS, but it's a free world otherwise. Go post it wherever you want to post it. Wear a t-shirt. It doesn't matter. Post it, display it, show it. It just can't be done in the MLS. And that's that part is going away. So we know that. It's A to Z otherwise, as far as what you want to do with the offer of compensation and how you want to display that, or publicize it, or advertise it, or disclose it to the world.
Okay, thank you for that. A few other things, just a brief question here, and I don't know if you know the answer to this, Grant, but Jackie's asking, do you know why NAR decided to settle?
Well, I think it was an economic decision. I think you look at the judgment. Losing stinks. Nobody likes to lose. Okay, nobody likes to lose in anything, and so they lost the trial in Kansas City, and they lost because of that loss, they were facing a responsibility for close to $5 billion. That's with the B verdict, and so that's impossible to recoup. And so, yes, they could have appealed it. And yes, they could have won on appeal, but they decided that from an economic standpoint, and from a membership standpoint, and from an industry standpoint, this was the better route to take. And so, can they be criticized for doing it? Of course. I mean, that's just part of the game. You make a decision, you're going to be subject to criticism. Could they have won on appeal? Maybe, possibly, but it was a risk. Litigation is one thing I keep saying about litigation, is consistently uncertain. So you don't know what would happen. So they took a decision to settle on these terms, which presumably and legally will take away all the claims that could exist for, like I said, members, brokers, associations, and MLSs.
Okay. A great question that just came in from Denise. Will it be allowed to use the words compensation offered or something along those lines in the MLS?
No. Let me say it again. No offer of compensation. Nothing, no field, no mention, a ban, a free speech ban. Let's just ban on speech involving compensation in MLS.
Right.
And you can do that. I mean, those rules can be made. That's not some First Amendment issue. I just sort of lightly threw that in there. But there's a ban on compensation discussion in the MLS pursuant to this settlement agreement. Okay. There is no ban on compensation discussion outside the MLS.
Very good. And I see people asking, what about attachments? What about if it's in Showing Smart? So again, tell us the reason that it could not be displayed within Showing Smart?
Well, because Showing Smart is operated by HRIS, which is owned by an MLS, which is owned by an association, HAR. And so those are all part of the settlement agreement. And the
Mm-hmm.
settlement agreement does not allow any of the associations or affiliated MLSs to be directly or indirectly involved in showing compensation for, or the offer of compensation for a buyer's broker in any capacity, whether it be in its MLS or in Showing Smart. Any sort of operation that it has or operates can't be the source of the compensation. It has to be
Mm-hmm.
somewhere else.
Okay, very good. A great question that I just saw come in from Roland that maybe people haven't really thought about too much yet. He said, are open houses considered a first showing? So are they considered a first showing, and would that require a buyer's rep agreement for unrepresented buyers?
It's a good question. I think that, that's going to be, there's going to be some trial and error on this timing of the buyer's rep agreement. They say, according to the settlement, it has to be in place before you tour a home with a client. So as an open house touring a home with a client doesn't on its face appear to me to be that situation unless you're accompanying your client to the open house. If they're just randomly showing up to an open house or showing up to it on their own
Mm-hmm.
without your involvement, doesn't seem to be kicking or putting to effect the time that you need that buyer's rep agreement. That would be just understanding the question. That would be my position on that. I mean, I think the theory is that touring a home with your client is sort of a hands-on evidence of me representing this person in this transaction, and that the public can see that. So
Mm-hmm.
if that's the case, then I need to have an agreement in place showing that. So I don't know how they came up with that as the kind of the benchmark on when you get a buyer's rep agreement. I mean, presumably you would even get it before that. I mean, presumably in a perfect world, you'd get it when you first start discussing any sort of properties, much less looking at properties. If
Mm-hmm.
you start feeding information to your client or potential client about properties to look at, or start answering questions about properties or the industry and da 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 da, you should go ahead and get a buyer's rep agreement then, because you're sort of performing services for this person who should be now your client, because you're now answering all these questions and providing advice. So get the agreement in place then. Don't even wait for the first tour of the home. But I think they looked at that as probably some benchmark event that says, okay, I'm showing up to this property, I'm walking them through the house, we're looking at this, da 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 da.
Mm-hmm.
This is buyer's rep agreement territory. Get the agreement in place. Maybe that was their thinking on that, but I say get it in place before that if you're
Okay.
actually doing stuff for the client.
Very good. So there are some more resources that I did want to briefly mention. The Andrea actually was asking, does HR have a site for us to find information on the talking points as we're discussing? That is an excellent suggestion, Andrea, and I'm sure we can work on that. Our communications department has been trying to compile as much as we can to keep you guys informed. But I did want to mention, and we can share the links for these in the comments, some educational opportunities that you could take advantage of. One is the accredited buyer's representative designation being offered both locally and by NAR for free. There we can share a link to where you could take it locally through HAR. Also a link to where you could take it through NAR. The biggest difference between the two is if you're taking it locally through HAR, you're eligible to get CE credit for it. But either way, whether you take it from us or NAR, it is free. We are also offering once a month a value propositions for realtors class. I had the opportunity to take the one that was scheduled for last week and sit in on that, and it was great. And I would encourage our members to look into some of those upcoming classes. It's a 3-hour CE class that you can take from HAR, and we can share the link for that in the comments as well. Another thing that we wanted to just quickly address here, Demetria said, are there any PR campaigns regarding the value or benefit of buyer representation to kind of offset some of what we've seen in the media? I don't know, again, maybe Grant, anything nationally, but I know locally, absolutely. We're doing all kinds of stuff behind the scenes to help promote the benefit of a realtor and to try to dispel some of the miscommunications that we've seen. Is there anything you want to add there, Grant?
Yeah, NAR is doing what they do, but we're going to do what we do here locally, and so
Mm-hmm.
we have internal communications that are working on these issues and providing information to the public and to the members, and also we're engaging a consultant to help us in that regard and providing information about anything from the lawsuits to the settlement to the practice to the future. And so all of these things are being mixed up and being baked in the oven, and hopefully will be presented and usable and work for the public, for the members, and for our industry.
Yes, very good. So again, I would encourage those who missed the beginning of this program to watch the replay. Of course, this is all recorded. You can watch the replay on Facebook and our YouTube channel. A few other things I wanted to mention before I get some final thoughts from you. Grant did provide us this slide, NAR settlement points that we can that you can definitely look at. One thing, and I did see a few questions around this, Grant, if you could just quickly tell us on number 3, can you give us a little more detail there?
Okay, good question. Meaning, back to my point that offer of compensation is live and well. You, as the broker on your website or any website other than anything related to the MLS, but let's just speak about a broker website, you can have on your listings offer of compensation. So somebody, a consumer or an agent or whoever, can come to the broker website, look at the listings the broker has, meaning those are broker listings, that broker's listings, and in that broker's listings, there can be publication of the offer of compensation, or somewhere on the broker's website, the offer of compensation related to the broker, that broker's listings can be provided. So getting back to my point, offer of compensation can be anywhere, everywhere, but nowhere in the MLS. Just remember that. I just came up with that. So take that home with you. Anywhere, everywhere, but nowhere. Nowhere
Okay.
being in an MLS.
Okay. Very good. And I do see someone else said outstanding class. This was in regard to the value proposition for realtors class. Rhonda Power just commented that she took that class last week as well, and she highly recommends it. Excellent. So it looks like we've answered quite a bit of questions. I'm sure there's some I may have missed. So we will continue to answer questions in the comments even after this is over. So whether you're watching live and your question didn't get answered or you're watching the recording, we will try to answer all of your questions. Grant, thank you so much for your time today. I know we only have just a couple quick more minutes with you before you need to head off to another meeting, but is there anything else that you wanted to share with our members today?
Well, Christina, you do a great job, and thank you for allowing me to come on here and talk about it. Like I said, there's always change in this industry. This is another change. Everyone will come out ahead. I think the key to remember is that the offer of compensation is alive. Just the structure of having it in the MLS and knowing that commission to some sort was sitting there and waiting for me at the end of the process still exists, but not in the MLS.
Mm-hmm.
So that certainty of perhaps a buyer's agent getting paid can still exist. It just has to come directly from the seller or the listing agent to you, the buyer's agent, or in some manner communicated and agreed to. And that's good for the industry. That's good for the clients. It's good for the consumer. And like I said, it's just not something the MLS will be a part of anymore. But the concept and the theory of it still exists and can still work and can still be beneficial to all the parties involved in a transaction for future home ownership for those seeking a new home or another home or whatever the situation may be. I think everything's going to work out well.
Very good. Just a comment here I wanted to read from Becky. She said, "Thank you. Change is always challenging, but we can do it." And definitely appreciate that. And people are thanking you for taking the time this morning to clear this up. I know there's still some questions out there. And again, we will continue to answer those questions on a daily basis as they arise or as answers arise on har.com/lawsuits. So if your question still isn't answered, please take a look at that website. Grant, again, I want to thank you for your time today. I know I threw a lot of questions at you pretty quickly, but you did a wonderful job tackling them all. I do want to also mention that next week is the beginning of April. It's April 1st next Monday, and April, as we know, is Fair Housing Month. We have several fair housing topics scheduled for April already, and we are going to be starting the month with Daniel Bustamante. He is with the Greater Houston Area Fair Housing Center, and he's going to be talking to us about fair housing challenges right here in the Houston area. So be sure to tune in next Monday at 9 a.m. Grant, thank you again for your time today.
Thank you, Christina.
Absolutely.
Have a great week.
You too, and have a great week, everyone. Bye-bye.